still more ahead with Experts on Call, the show focused on delivering relevant reliable, and researched. This is Experts on Call, the show focused on delivering leading-edge news and information on today's most beneficial products and services. This is Experts on Call on AM 650.
Welcome back. You're listening to Quay Pacific's Talk About Strata. I'm Stirling Fox, joined in studio by the Executive Director of the Condominium Homeowners Association of British Columbia and Province Condo Smarts columnist Tony Gioventu is back with us. And Tony, you were talking in our opening segment about the Civil Resolution Tribunal Act, better known as Bill 44, just introduced in the last week or two by the government of BC. They're kind of on a bit of a roll here because it's in the last few months. This is the second item they brought in. Just before Christmas, they brought in this act requiring depreciation reports for all strata properties in British Columbia. So what's going on in Victoria? Is the strata business such that it's coming to the attention of the government that it needs more attention from the government, and the government's finally getting on board? Is that what's going on?
Well, housing is an enormous industry in our province.
Yeah.
And in not only construction, but the existence of housing. If you look at strata corporations across the province, at any given time, strata corporations probably are holding $3 to $5 billion in their cash assets in their accounts. And they're, the strata, you look at the strata community from a GDP ratio, and it will be equally double of that. So it's an enormous part of our industry. And we have, in a lot of communities, we now have more than half of the constituents who live in condos. So, we've been working closely with government since about 2003. We started a number of initiatives. 2005, there were consultations, and the government took a hard look at, upgrading the legislation. Things have changed. Technologies have changed.
Sure.
Case law happens, and it's still relatively young legislation, but it's good to have upgrades, and it's time to fix some of the big things. And some of the big things were, people planning for the future, maintaining, repairing buildings. And then, of course, the real thing that just popped into the ledge a few weeks ago was, of course, the introduction of Bill 44 around dispute resolution. So actually having strata owners and strata councils actually having a place to go to get some reasonably reliable dispute resolution that's going to be time-saving, that's going to be accessible no matter where you live in the province, that's going to be a binding decision, is going to help stratas to move on from their disputes.
Yeah, I want to come back to this, the other stuff we talked about, the depreciation reports that are now law in BC as of just a few months ago. But let's pursue this Civil Resolution Tribunal Act that has just been tabled and will likely become law, one would hope, this calendar year at least. What sorts of disputes will this address most frequently?
Well, I think most disputes in strata corporations are over three things, basically: bylaws, money, and maintenance and repairs.
Okay.
Right? They're all about those. They all tend to focus around those three areas for the most part. Disputes that deal with residential tenancy and human rights tribunal will still go directly to those jurisdictions.
Okay.
They won't get brought into this process. But bylaws, good example. We talked a little earlier about, the strata has bylaws that prohibit pets,
yes,
but yet 3 council members have dogs and cats.
You use that
right?
example, right?
And that's not a rare example. It's a common enough example where, what's good for the goose is good for the gander necessarily, but that's not how a lot of strata corporations function. One of the goals is get on strata council so you can get your own way and you get what you want out of it.
Exactly.
And so what do you do with your strata council when the strata council no longer complies with the legislation? What do you do with the strata council when you're supposed to have an AGM every year, but you haven't had an AGM in 3 years? Right? What do you do? What it essentially means is an owner or a group of owners have to mount an action in Supreme Court to get orders of compliance and enforcement.
These days.
And that's incredibly expensive.
I can imagine.
So that goes away with the tribunal. An owner goes to the tribunal to make an application, goes through the dispute process. And one of two things will happen. And I think what we'll see is strata corporations, once they realize they're going to be going down this trail to the tribunal, tribunal office to be ordered to comply, they're probably just going to say, okay, let's just comply and get on with it.
I'm thinking of the old Mark Twain line, he who chooses to defend himself has a fool for a client.
I would suspect that could be true. Yes.
Yeah, no, so you're not going to go anywhere near the Supreme Court of British Columbia without a lawyer.
Right.
Is it going to be such, though, that when the Civil Resolution Tribunal is finally a fact, that you won't have to have a lawyer to go and plead your case before this particular body? They won't forbid you from bringing one with you, but you won't be required, as you would certainly almost be required to do in Supreme Court.
Well, I think that we will still continue to recommend that the parties, whoever they are, still get legal advice as they go through this process.
Right.
And maybe that's even some coaching on how to negotiate for the first 2 or 3 steps of the tribunal process to get what's reasonable for both the parties,
Okay.
and so that it's some equitable solution, so that there's some satisfaction in solving the problem. But I think when you get to things like an actual adjudication in a hearing, I think the parties need to seriously think if they need legal advice and legal defense to be able to deal with that. You know, there's an attempt of informality that says you don't need lawyers, you'll come to us, we will have people appointed to the tribunal who'll be competent, who can make a decision. Well, that doesn't necessarily assure that your legal representation and your legal interests are protected. Right. And so I think at some point someone's going to have to say, you know what, I want my lawyer there with me. That's just the way it's going to happen. And the tribunal will deal with that accordingly. So we're going to see how that works out once the rules of the tribunal are created.
What's the split, Tony, on beefs between owners and strata councils and strata councils and owners? In other words, the owners initiating the grievance against the strata council, or the other way around? Which is more likely?
Well, I think owners have a lot of grievances with strata councils, but they're not initiating disputes because it's too costly.
Okay.
Right? And so that is
more trouble than it's worth, the sort of
more
thinking?
trouble than it's worth. And right now, if you go to small claims to dispute over, the strata fined you because they claimed you caused $900 damage to landscaping and you're disputing it.
Mm-hmm.
If you go to small claims, you could be waiting 24 to 30 months before you get into an actual decision. Right? It's a long period of time. By the time that's all gone, everything's changed.
Sure.
You know, the strata council is not even the same strata council. The property manager is not probably the same property manager. People may have sold since that happened.
Mm-hmm.
The one thing that compels this process is that an owner can compel the strata corporation. It's mandatory into the tribunal process.
Oh.
Right. So it's mandatory the way the bill reads. And so if an owner commences this dispute resolution process through the tribunal, the strata corporation must participate, unless there's already a separate action or court action involved regarding this issue.
So it's like calling the cops. If you call the police department and complain about something, someone will have to go out and investigate because you called and initiated the process.
Well, we always said there were no strata police, and that's about to change. There actually will be a strata sheriff, which is the tribunal. From an owner's perspective, and owners are, they're single minorities. They're, while the odd owner decides, well, sure, you know what, I'll spend $50,000 and let's go to court and get this matter dealt with. Most owners can't afford that. They're disenfranchised. They don't have the money to do it. They frequently are isolated from the rest of the owners. So this gives them the ability to have a compelling mandatory way of going forward. The strata corporation has the resources of the corporation to enforce their bylaws, right? They can go to court. They can force parties into courts. And one of the things I think that we'll see happen is, because of the economics of the courts and everything that's involved, even though the strata corporation may be commencing a claim with respects to an owner regarding bylaw enforcement, it's not mandatory in that direction to the owner. The owner may say no, or the owner may say, we're taking this to court. But it will be in the interest of owners for the most part, because the economics alone will mean they're still going to get some solution, and they're going to be able to deal with this in a much less formal way, but a much more economic way.
What happens after, and you've seen probably hundreds of these in your years with the Condominium Homeowners Association of British Columbia, what happens when, whether it's the Civil Resolution Tribunal that is coming down the pike, or a court situation that exists already, when two parties, the Strata Council and an upset owner or group of owners, tee off against each other in court? it's acrimonious, it's no fun, it's nasty, etc., etc. At the end of the day, no matter what the decision of the court, these people still have to live with each other. How awful can that get?
Well, and I think that's one of the things that the tribunal can play a good contributing role. The tribunal, by the way, the officers who are going to sit as tribunal managers are
Right.
going to be appointed by cabinet.
Okay.
So in the end, the legislation sets out some guidelines and some very clear directives about competencies and experience and knowledge with respects to this discipline. So there's an obligation to put people onto the tribunal who actually have experience with stratus. And
Rather
actually
than some political hack appointment.
well, we hope so,
Right,
right?
right.
We certainly hope so. And the decisions of the tribunal will be published on a website. So they become binding decisions, which everyone will be able to read and understand what the outcome of those decisions are. And those decisions can be appealed. But at the end of the day, that's the point that most people miss. If you're going to get into a horrid conflict, you got to remember you're going to live here together at the end of the day.
That's right.
Yeah.
Yeah, and I would imagine on more than a few occasions, somebody moved after the thing was over, right?
It is not inconsistent. That is certainly what people contemplate. But I can tell you one thing that happens at the end of it. Rarely do either of the parties get out unscathed. Everyone pays the price for it.
Interesting stuff. CHOA.bc.ca, CHOA being the acronym for the Condominium Homeowners Association of British Columbia. Terrific website. If you're particularly just sort of looking at the whole condo strata segment of real estate as a potential landing spot for your plans in your next move, CHOA, CHOA.bc.ca is a terrific website, a great place to get some homework done and really get your teeth into some of the issues that you should be paying attention to as a potential buyer. Tony Gioventu is the Executive Director at CHOA. I'm Stirling Fox. This is Quay Pacific's Talk About Strata on AM 650.
Delivering relevant and beneficial consumer information. This is Experts on Call. And there's more still ahead on AM 650.